Thank you everyone for being here. Thank you for joining. I am so excited to be joined by Victor Brown as our presenter today on a topic very, very near and dear to my heart, college sports. Thank you so much for taking the time to be here today. Victor is actually one of our LLM alumni here from USD Law. And he must have loved the university so much that he just could not leave and now had to move into sports here. He is the Assistant Athletic Director for Compliance at the University of San Diego, where he serves as the primary legal and regulatory advisor for the athletics department. Before joining USD Athletics, he worked as a project attorney for Motley Rice LLC on the opioid litigation. We are so happy to have you. Thank you again for taking the time to be here, and I will hand it over to you, Victor.
Thank you very much. Thank you for having me here. Let me go ahead and share my screen. Can everyone see my screen fine?
In just a second, it's loading. There it is. Perfect.
Awesome. Well, good afternoon and good evening to everyone. Like I said, my name is Victor Brown. I'm the Assistant Athletic Director for Compliance here at USD. I've been here for about 4.5 years, going on my fifth academic year. And like Feline said earlier, I was, before working at USD, I was working as a project attorney at Motley Rice LLC, where I was actually focused on the opioid litigation and the national class action lawsuit. And prior to working there, I actually interned in the compliance office at the Citadel, which is a military institution in Charleston, South Carolina, during my time at Charleston School of Law. So in terms of my education background, I was a former student athlete as well, and went to school in the East Coast over by Pittsburgh, called Waynesburg University, and then went down south because I was too tired of the cold, and went to law school at Charleston School of Law. And in terms of how I got into athletics and sports, when I got to law school, I always wanted to work in sports, but didn't really have an idea what that entailed. At first, I thought I was going to be a sports agent. And then when I got to law school, I got a really good realization of what an actual sports agent is and not what is shown on social media and TV, where a lot of those sports agents were working 80 hours, 40 to 60 hours a week as personal injury attorneys and working an additional 40 hours on the side doing sports agent stuff. And most of their athletes were focused on undrafted football, undrafted basketball agent, student athletes coming from USC, University of South Carolina, and Clemson University. So I kind of got deterred from going down that pathway. What led me into wanting to work in compliance was I was at a guest panel speaker, and there was someone from the Citadel who talked about compliance, and I kind of really drawn to that in terms of the administration side of things. And then as I started to go into more deeper dive of what was happening in college athletics, it was a perfect opportunity for me to move forward in college athletics for me personally. And then, like I said, I've been here at USD for about 4.5 years. I started as the assistant director of compliance here in 2021 and mostly was focused on day-to-day compliance activities. And then I was promoted to director of compliance last year in the summer of 2024. And then thankfully, again, I was promoted again to assistant athletic director this past summer, where essentially my role is now sort of shifted, where I still focus on compliance, day-to-day operations, but now I also help facilitate and oversee our revenue sharing program and help in terms of that aspect as well. So in terms of what compliance entails, so essentially I like to explain compliance in like three pillars. Our essential day-to-day role is monitoring, reporting, and education. Working compliance is it's enjoyable. There's not a dull day, and every day there's something new I'm working on. And essentially, the way I like to explain compliance is we're essentially per se in-house counsel for the athletic department. And we're essentially here to ensure coaches, student athletes, and staff that they're adhering to NCAA bylaws, but we're also here as a resource and guide for our student athletes, our coaches, and our staff, and as a tool for our athletic department as well. Working in compliance, you have to have the ability to problem solve, find solutions pertaining to some of the areas listed above, such as like financial aid, recruiting, athletics eligibility, and admissions, but also our coaches rely on us just based on our interpretation and staff of specific NCAA bylaws. Like in-house counsel, you have to wear multiple hats and provide guidance in areas that you're not necessarily experts in. And the same thing goes for the compliance. And especially at the mid-major level, you see compliance officers, there's mostly only a staff of 2 to 3. Here at USD, we're a staff of 2 full-time staffers with myself and my supervisor, Jacob. And then we also have 2 paid part-time interns. But if you go to like bigger schools, like at the Power Four level in the ACC, SEC, Big Ten, some of those schools will have compliance officers between 4 up to 8 staff members where they're able to divert and divvy up work responsibilities in certain models. Here at USD, Jacob mostly focuses on more of the roster side of things, where I focus a little bit more on the financial aid piece and the rev share piece. But again, we are hand to hand. We work with all our coaches on a variety of matters that listed here in terms of core compliance functions. One other piece in terms of compliance is we have to report violations that are committed in any of these areas above, which adds a bit of an adversarial side to the job. But in terms of the way we work, we're not someone that's going to be looking over your shoulder, always monitoring, always reporting. I think for us, we're someone that wants to report between 6 to 8 violations a year. And obviously, our goal is, especially the education piece, our goal is to, provide as much education to our coaches in order to prevent any major infractions. Obviously, we can't see everything, we can't monitor everything. Things will slip through the cracks. We'll have violations. And so it's once we have those violations, it's more of just like, okay, how do we prevent this in the future? And so one of the biggest pieces is we have to implement a lot of processes and procedures, specifically with recruiting, specifically with financial aid, and especially with admissions. We are essentially facilitating the admissions process a lot. And one of the examples of that, something I had to learn that I'm not necessarily an expert in, is international admissions. The visa process, I wasn't an expert in that. I didn't think that's something I needed to know, but quickly had to learn and shift and understand the visa process and how student athletes can get visa appointments, the chance of them getting admitted in a timely fashion to get their I-20s processed. I had to become an expert in that essentially because we do have a lot of international student athletes and our coaches do recruit internationally abroad, especially in our Olympic sports and especially our basketball as well. So in terms of the path of revenue sharing, I just want to kind of give a bit of a background and a timeline of change of essentially how we got into this post-house settlement era where essentially student athletes are able to receive direct payments from the institution. So pre-2021, pre-NIL, pre-house, additional compensation to athletes was strictly prohibited. And as for example, pre-2021, coaches couldn't even provide student athletes meals on an occasional basis. So if they wanted to say, hey, how's everything doing? Let's go get lunch just to talk about how life is, especially if the student athlete is having some well-being issues. That was something that was strictly prohibited prior to 2021. And the only compensation athletes were essentially getting was tied to their room and board stipends and also cost of attendance stipends. And then as we shift into 2021 in terms of the NIL era, where sometimes it's called the Wild Wild West, but I think it's still the Wild Wild West now, even in this post-house settlement era. This was triggered by the NCAA versus Alston Supreme Court ruling. Now, the Alston Supreme Court ruling didn't mandate NIL, and the case was mostly focused on educational benefits. But one of the key pieces was Justice Kavanaugh's concurring opinion, which essentially looked at the broader system of NCAA and indicated that restrictions on athlete compensation violated antitrust laws, which resulted in the transition and the legalization of NIL. So essentially, initially in 2021, the NCAA indicated that student athletes can earn compensation based on their name, image, and likeness. And it was a very broad rule. And it wasn't anything actually in legislation. It was just a memo where essentially that there had to be some quid pro quo where a student athlete had to do some sort of work in order to earn that compensation, the free gear, the free merchandise. And the only other rule was that institutions could not facilitate or could not be involved in the NIL deals. And essentially, any money that they were earning for their name, image, and likeness had to come from third-party vendors, corporations, brands, and things of that nature. One of the things that came out because of that was the birth of the collectives and the rise of the collectives, which essentially was consisting of alumni and donors who were essentially filing 501(c)(3)s for tax exemption purposes and essentially paying the athletes directly through NIL compensation. Coupled with the transfer portal, you started to see the rise and increase in tampering. especially from the NIL collectives, where they were essentially reaching out to student athletes who weren't in the portal, trying to entice them to go in the portal to come to their school in order to receive payment. One other issue we were seeing was like the lack of fair market value for NIL deals, especially in football and basketball and men's basketball specifically. You're seeing some of these athletes sign six, seven-figure deals. And in terms of like the quid pro quo, all they had to do was maybe sign a couple memorabilia, like sign a football, make one or two appearances, which is not really compared to the market value of what they're receiving. That wasn't essentially up to value in terms of how much money they're receiving in order for that little work. And then during from 2021 through 2024, the NCAA was providing a different additional clarity, but essentially there was no legislation or enforcement during this time period. You were hearing horror stories from student athletes that would essentially enroll at a school and indicate that they were promised to pay if they enrolled at the school, and when they would enroll at that university, there was no payment. And especially since the universities were supposed to not really be involved initially, you were seeing a lot of coaches kind of removing themselves and indicating like I had no idea, I wasn't involved. Everything that they were discussing with that collective was not in writing, it was verbal. So you were hearing horror stories across the country where kids were alleging that they were essentially induced to enroll at the institution and they were not getting payment before their enrollment. Also, from a legislation standpoint, the NCAA wasn't really enforcing the NIL rules. And then when they even tried to enforce the rules, you started to see states create laws to essentially indicate NCAA cannot enforce rules regarding name, image, and likeness, especially in the SEC. You saw states like Missouri, Arkansas, Tennessee, even Texas uh, create rules and state legislation to essentially restrict the NCAA from enforcing their NIL rules. And then at one point, I believe it was the University of Tennessee, the NCAA did try to impose a NIL violation in terms of tampering and also having boosters communicate with athletes that are on visits. And the state attorney general for Tennessee sued the NCAA, which essentially had the NCAA back off. So it was kind of a really wild, wild west period in terms of the NIL era. And especially for compliance office, so a lot of compliance offices were like essentially the de facto to handle NIL matters because at the end of the day, we're the office that's in charge of reporting, disclosing information, and also doing the monitoring standpoint. And especially at the mid-major level, that put a lot of pressure on offices, even like us here at USD. We had student athletes that were essentially requesting us to review NIL contracts, review agent representation agreements for help. And part of it was trying to, mitigate the risk where we didn't want to feel like we're being too involved initially in terms of facilitating and handling their deal, but also from a student well-being and a student holistic standpoint, we wanted to make sure that these students were essentially not signing their lives away. And there were horror stories during that period where student athletes were signing their name, image, likeness rights for their entire life, especially for those football and basketball players where they had a shot of going pro. You did see some agents representation and also some of these NIL contracts with companies and brands where they were essentially taking advantage of these student athletes. And then also the other part was essentially reporting violations. One of the rules with NIL was that student athletes had to report those deals, and it became a bit of a mess, especially in terms of the process and procedure, especially for a smaller office like ourselves, having to do we really want to commit time to reporting NIL violations? And we also felt it was counterintuitive for our time and also for the student athlete. Like, do we need to be looking on Instagram, looking at student athletes' Instagram, seeing if they're posting any sponsorship deals or promoting any brands, and essentially bring them in our office saying like, "Hey, I saw this Instagram post. Can you please explain it?" It felt counterintuitive, and that's not what NIL, from my standpoint, I think also my supervisor Drake would agree, that's not what NIL was supposed to be. And then also another issue was our international student population. International student athletes are on F1 visas, so they can't work and earn compensation. And so unfortunately, we had high priority athletes here that had huge success, especially when I first got here, August, a men's tennis player, and also we also have a lot of high achieving student athlete population from the international standpoint that wanted to earn money from name, image, and likeness. And obviously, we will work with our international office to see what guidance they provided us. It's very restrictive, and the only time they could essentially earn money is if they were back at home in their home country or they were working with some sort of brand or company that's not based in the US. And it was hard to try to navigate that and uh, hard to provide guidance to our student athletes because they would see other student athletes across the country that are from their home country earning money, posting about it, brands. We even saw in some schools where they're allowing student athletes to sell their gear in stores. And even when we asked our international office if that was permissible, it was kind of a no. And so you would see across the country, some international offices were more restrictive. Some of them were a little bit more liberal in terms of what international students can and can't do. I think I give credit to our international office because they fielded a lot of questions from us because we just weren't equipped in that area from an international standpoint, and we didn't want to jeopardize our student athletes' visa, and also didn't want to jeopardize their chances of staying in the States if they wanted to continue living in the States after they completed their college degree. And then we shift into the post-house settlement, which was effective on July 1st, 2025. This is resulting from House versus NCAA, which was a league case, but it was also consolidated with two major similar antitrust actions from Hubbard v. NCAA and also Carter versus NCAA, which all challenged the NCAA's limits on athlete compensation under federal antitrust law. Essentially, the settlement of House permitted institutions to directly compensate athletes, implementing a $20.5 million revenue sharing cap, which is essentially the most that a school can provide in terms of financial aid, benefits regarding to rev share, and also it provided the framework to bring NIL in-house. So institutions had more control over NIL and essentially kind of removed the collectives. Now, collectives are still around to this day, but I think having NIL in-house, it's more cleaner. It's true on NIL where student athletes are now promoting themselves in terms of our university marketing standpoint, but also out into the community where we are able to help facilitate and bring deals from businesses and brands in a local community to essentially pay these athletes. Also, one of the biggest changes as well, which we'll discuss later, is the change from the traditional NCAA scholarship limits, which expanded and it changed and expanded towards roster limits, which we'll go into more detail a little bit later. And also, it deregulated a lot of NCAA bylaws from an amateurism standpoint, because at the end of the day, one of the biggest pieces for the NCAA is that student athletes were amateurs. And due to the House settlement, that amateurism model shifted, and essentially a lot of that has been deregulated. And another big piece as well from the House settlement, there was a $2.8 billion payout to former and current student athletes who were previously restricted from earning compensation. So from 2016, essentially until 2021 or 2022, student athletes and former student athletes were able to submit a claim to receive compensation, and that compensation varied based on what school they enrolled in, what sport they enrolled in, what sport they were participating in, and what based on like the formula and the method that they did it, how much they could earn. So in terms of that $2.8 billion payout, I think roughly 75 to 80% went towards football. The rest of it went towards men's basketball. It was 80% to football, and I think about 20% or 15% to men's basketball. And the remaining portion was split amongst women's basketball and the rest of the Olympic sports. So in terms of big payouts, you only saw big payouts towards the football and men's basketball for any back damages. So in terms of the new legal reality, one of the biggest changes, especially for here at USD, was our interaction with our general counsel. For most of my time in my first 3 to 4 years here at USD, I had no interaction or communication with our general counsel, and usually any interaction from the athletic department with our GC office was mostly coming from the athletic director or one of our senior associate athletic directors. But since the start of 2025, the communication has increased drastically at times, and during certain periods, there was, especially during April, May, June, as we were gearing up for this new model of revenue share, we were having daily communication. And for our office, we were the ones that created the revenue sharing contract. I know our athletic director Kimia put us in charge of that, and essentially there was no guidance on how to do that. I remember reaching out to colleagues and trying to figure out, is there a template we can use, or how are you guys doing this? And there was no blueprint. And if there was a blueprint that school found out, their council office restricted them from sharing that information to anyone else. So we kind of had to create our own contract and then use general counsel as a resource to understand legally what was permissible to add in there from a university standpoint and what other provisions and terms that we should put in there from a risk mitigation standpoint in order to protect us and the institution from lawsuits. Another increasing thing that happened in this new model, and even right before House was adopted, was the student athletes having representation, especially in football and basketball. In the agency world, it's a very unregulated market right now in college athletics, and We're seeing a lot of agents not really be certified based on state requirements. They're not certified appropriately as agents. We're also seeing, because of the unregulated market, some of these agents are often charging high commission terms. You know, professional sports like the NFL, NBA, those agents are only capped at like 5% in terms of commission. Here in college athletics, we're seeing agents and even some of the well-established professional agencies that are dipping into the college atmosphere, charging commission between 10, 15. I've even seen 20 to 25% commission off of a student athlete's compensation, which is utterly ridiculous and unfair, especially in this market where it's unregulated. We also seen agents present themselves as experts, quote unquote, and essentially misguide and misinform our student athletes with regard to their eligibility, which gets a bit tricky for us, in terms of trying to explain why that this student athlete's not eligible. As one of the examples, last year, the starting quarterback currently for the Vanderbilt Commodores, Diego Pavia, sued the NCAA to indicate that his seasons of competition he used at the junior college should not count as seasons used. And because of his argument and his attorney's argument, the court ruled that he was correct on that, and NCAA actually adopted a waiver for this year only to allow athletes who would have exhausted eligibility last year to have one additional season of competition if they competed in the JUCO. But also that it provided a lot of misinformation there. So we, especially from the football side, where there's a lot of junior college athletes that start there and then go to the D1 level, we had a lot of misinformed student athletes and we had a lot of misinformed agents where these agents are charging these student athletes money for representation and they're claiming that they're experts and they have no idea what the rules are. And so sometimes those conversations can be tense, they can be a bit tricky, but not all interactions are bad. I've had communication with attorneys representing student athletes who are requesting waivers to be submitted on their behalf, and we've worked in collaboration and it worked perfectly well. But also we've had issues with agents who are a bit abrasive, don't want to take no for an answer and think that they know everything and we're just here just for no reason. And so it did get a bit tricky in certain aspects. And to tie that off with, working with general counsel and also the agent ecosystem, now that eligibility has a monetary component to it, you start to see compliance officers taking on added pressure, especially in handling situations and mitigating any potential risks, especially from the waiver process. You start to see, especially here at USD, coaches, not coaches, but agents and athletes requesting and sometimes demanding solution through a waiver process in order to get one more season back just so they can play and try to earn compensation. And from the player and agent side, not understanding the waiver process and essentially requesting us to submit frivolous waivers that we know are dead on arrival just for a chance or a hope. It's just extra work for us because those waivers take time. We have to provide our own statement. We have to gather that information from the student athlete. And then we also have to do the research from a case precedent standpoint. So those waivers take a couple days to get together and submit. And putting all that work in, knowing that those waivers are dead on arrival is kind of a waste of time. And also, especially with the eligibility standpoint, especially my time here at USD, we even seen athletes try to preserve the season, where if they get hurt early in the year, they might try to delay their rehab and their therapy to kind of just preserve the season and not be clear for competition and get that season back. We've also had a couple instances where student athletes forged and doctored medical documentation to make it look in favor of themselves just so they can get a season back. And so trying to handle and mitigate that risk is pretty hard, especially in one situation we actually did submit a waiver and found out that the medical documentation was doctored. So we had to backtrack and figure a solution because the NCAA could ask us more about that, and that could have been an issue from a ethical conduct standpoint. And also for myself, I remember one of the times where I was reaching out to the school and the school wasn't responding, and I kind of was getting a little frustrated, only to find out that the student athlete just strictly just forged that medical documentation. So it made me look a little embarrassed on myself. And also another issue we've had is trying to tell athletes no. Some of these athletes refuse to take answers, and during this early stage of these athletes saying no, one thing I would say, especially during this time where everyone is suing the NCAA, I would just say, when in doubt, just file a lawsuit against the NCAA, just to show like how ridiculous it seems for the athletes. And think about, like, if I really want a season, I have to go pay for an attorney and submit a lawsuit. And I was doing that pretty oftenly because knowing that most of our athletes wouldn't go take that step further. And then unfortunately during the summertime, a student we there was an athlete that did sue the NCAA, and and the USC was mentioned in it. So had to backtrack and reevaluate how we express our message to these student athletes and kind of identify which ones are yellow flags, which ones are red flags that we provide to our athletic director and also provide to our general counsel. Because right now it's just with all the ever-changing laws and rules regarding the NCAA, it's a bit difficult, especially from a compliance standpoint, where we always try to help the student athlete, but at some point, no is a no. And we always will try to figure a way out. But if it's no, we just have to say no. And sometimes these athletes are not taking no for an answer, unfortunately. So in terms of the new economic model, so essentially, like I said, the $20.5 million cap is essentially a salary cap, which essentially includes revenue sharing payments, athletic aid disbursement, and institutional NIL payments that go to that cap. Also, what we saw was traditional scholarship limits were replaced with expanded roster limits. And so for institutions like USD, managing that cap in sports that are not fully funded is a transitional challenge. And the previous model in terms of NCAA scholarships were it was an arbitrary scholarship limit where essentially NCAA indicated, like, for example, football only had 85 scholarships. And there was no limit on how many people they can have on the roster, but there was a limit on how many scholarships they can give to student athletes. Now with the change to roster limits, for example, football has a roster limit of 105. So it's up to institution, but the institution can fully fund 105 full scholarships if they choose to do so. Same for other sports like baseball. Their arbitrary number was 11.7 of equivalency, and then now it's a 34 roster cap. And so for schools like USD, we're not every sport's not fully funded. And so in terms of managing that and also the roster replacement and turnover, especially in some of our non-revenue sports and our Olympic sports, where budgeting is a bit tighter, puts our coaches at a disadvantage. They benefited off of a model in terms of equivalency where although you're spending X amount, if as long as they didn't go over that 11.7 equivalency or whatever that arbitrary number was, they were totally fine. So they didn't have to worry about just how many dollars were spent and more of just, well, what percentage of equivalency am I giving my student athlete? Is it 20%? Is it 30%? Is it 40%? But now as you're focused on how much money you're spending and how much money you have left remaining, it gets a bit difficult. And so for myself and my supervisor Jacob, what we did initially, especially at the start of March, was have meetings with our coaches, communicating them for the past couple of months, gearing up for us, saying, listen, this is your budget. Don't go over this budget. And before, if a coach or a team went over the scholarship limit, there were NCAA limit consequences imposed. Obviously, there's still unsavory consequences imposed if you go over like your 105 or your 34 for like baseball. But for sports like here at UC that are not fully funded, going over a budget, there's no consequence from an NCAA standpoint. It's more of an institutional action. So we've had coaches try to like ask like, hey, can I just spend and fundraise later? And that's something that, our athletic director Kimya and our business office as well has to navigate. And also from my guidance where coaches relied on me to kind of, we would say not intricate accounting, but figure out ways where we can essentially stretch the dollar from an equality standpoint. We can't do that anymore. And it's strictly how much money you're spending. So trying to rewire our coaches' brains and trying to shift from the old model into this new model has been a bit difficult. And because of this complexity, this has created a new in-demand position, especially in the sports of football and basketball, the general manager. The general manager role varies depending on the institution in terms of power. We've seen some institutions where the general manager has the authority to fire a coach. We see some institutions where the general manager essentially is just working hand in hand with the coach and essentially taking the negotiation side of things. But most general managers are facilitating negotiations, roster management, revenue share payments, and contract drafting. And you're also seeing a lot of, especially at the Power Four institutions, they're actually creating and hire a general counsel position to work within the athletic department to handle the contracts, the risk mitigation, and also sometimes the negotiations as well. But here at USD, it takes a village. So in terms of how we operate here at USD during this past summertime, this was a collaborative effort between our office, our athletic director Kimya, who essentially helped in the negotiation piece for our men's basketball program. As like I mentioned before, all these basketball student athletes are having agents now, and so that negotiation was led by Kimya and with the basketball coaches as well to ensure that obviously coaches are not spending too much money, but also coaches are not getting themselves in a difficult piece where they just kind of want to be focused more on like the recruiting and coaching side and not the monetary standpoint. And then our business office of one essentially was helping in terms of making sure how do we disperse these payments? What is the best mechanism to disperse these payments to the athletes? And then also our assistant athletic director of NIL also helped in that category as well. In terms of what compliance was in charge of was the roster management standpoint. So we worked with our coaches in terms of roster management, figure out who's on the roster, who you're moving, and especially with roster limits, we had to work with them hand in hand. And also, we essentially created the operational side of revenue shares. Like, how do we document all this? Where do we house how much we're spending on each student athlete? And we do use Teamwork General Manager, which is a platform that helps organize all that in terms of who's getting paid. How do we send those payments through there, but also we have to keep it in other areas as well as for documentation standpoint. And one of the other biggest issues with roster limitations that came up, which was also kind of prevented House from being essentially settled, was the roster limits essentially eliminated the traditional walk-on model. So essentially, because of roster limits, again, you can have 105 scholarships if you want, but for like schools like USD, we're not fully funding for every sport. You see a decrease in walk-ons. And so in order to get House across the door, there was a compromise and it was called the designated student athlete exception or quote unquote DSA, which essentially for any athletes that were on a roster last academic year who would have been removed because of roster limits, uh, can get the DSA tag. And that also include any student athletes that were high school prospects that were being recruited up until April 7th. They were able to get this DSA tag. And essentially what this allowed is institutions and teams to go above their actual roster limit. So, for example, the roster limit for football is 105. They could technically have 5 DSAs and have a roster of 110, but only 105 are counting towards that limit. And so for our coaches, we had to kind of be there to help provide them guidance on what to do there because a lot of our coaches didn't know who they should DSA tag. One thing I used to tell my coaches was like, just don't DSA tag your best player, obviously, because it'll be easier for them to transfer. But some of our coaches were having that a bit of a difficulty doing that because also with the DSA tag came a kind of disclosure message to the athletes saying like, hey, you are given this DSA tag, which means you would have been cut. If it was not for this DSA tag exception. So our coaches didn't feel comfortable doing that as well in certain situations, and we had to kind of coach them on how to deliver that message to our student athletes so they didn't feel like, wow, coach was really going to cut me during that time period. In terms of the governance and regulatory evolution, you're starting to see, because of this House Senate, we've seen the implementation of a power shift in terms of a more decentralized model, moving wholly away from being focused on the NCAA. So now in this post-House era, we have the implementation of the College Sports Commission, or CSC, which essentially is a new independent body created by the major college sports conferences, the ACC, Big Ten, Big 12, and SEC to oversee and enforce rules for revenue sharing, NIL deals, NIL disclosures, and roster limits following the settlement from House v. NCAA. The CSC role involves investigating violations, administering penalties, and managing compliance through platforms like NIL Go, which essentially is a platform that all NIL deals have to be submitted if they're $600 or more. And we saw issues with that as well through NIL Go, where student athletes weren't accustomed to reporting deals. Now they had to report them, and you saw a lot where deals were being denied on its face because of the fair market value or certain other aspects of it. And the problem was that these kids are already accepting the money and already doing this stuff before they got the approval. So there was a bit of a transition period there during this summertime. And then also there was a platform called CAPS, which essentially houses all the revenue sharing and reporting from our side of things that we have to work through on a day-to-day basis. Also, where our roster limits, we have to submit our rosters in CAPS as well for competition in order to get that approved. This, along with a combination of constant shifting of bylaws and regulatory frameworks, require compliance office to be even more quicker and effective in their communication interpretation in terms of these new rules in this new model of college sports. For instance, we've always known, even in the fall semester of 2024, we always knew that House was coming down the pipeline. But for a compliance office, we didn't see any sort of new legislation pertaining to revenue sharing, roster limits, financial aid, amateurism, and even in-house NIL until only like early to mid June, which and House was implemented July 1st. So we only had weeks in terms of educating our coaching staff in terms of and getting the DSA tags done. So that added a lot of pressure on compliance offices. And I know for us as a smaller one, we kind of had to start early in the process in terms of creating the budgets, creating the mechanisms and operational workflows to provide our coaches and explaining how this is going to work, especially the DSA tag and the budgets. There was times I was having meetings with coaches more often than none than usual. Usually before our renewal phase, I have a meeting with coaches maybe once or twice before July 1st comes when we have to send out renewals. Was meeting with coaches maybe 4 to 5 times from the start of March through July in preparation for this. Also, in terms, we required additional planning from our office to ensure everything was good to go to start paying some of our athletes, especially our basketball athletes. They all signed contracts indicating that they'll be paid on July 1st. So we had to make sure that everything was good to go because technically we would have been in breach of our contract with them if they weren't receiving that first payment on July 1st. And so we had to prioritize certain during periods where we prioritize maybe stuff from a admission standpoint or a benefits or participation award standpoint, we had to focus more on the rev share, make sure that was good to go, so there was no hiccups when July 1st came. And with the introduction of these changes in revenue sharing, roster limits, and in-house NIL, invites a potential risk for the institution. Title IX still has a role to play in this new post-house era, and obviously right now Title IX hasn't really been an enforcer at this current standpoint, but you are seeing institutions not really adhering to Title IX. Most of these revenue share payments are going towards sports that are revenue generating sports. So obviously, at a Power Four level, you're seeing that money go towards football, especially at the Big Ten, SEC level. And then also you have basketball to pay for. You're seeing that money go towards basketball, and you're also seeing it go towards women's basketball. But you're also seeing those Olympic sports that are considered revenue sports, but they're not generating as much revenue as like as a men's and women's basketball or as a football. They're not getting as much money. And you're also seeing across the board in a lot of institutions, they're reducing the amount of scholarships they're providing some of these Olympic sports for like a soccer, a cross country, a swim and dive, and even sometimes baseball and volleyball and softball. And so Title IX has still a role to play. And even with the back payments, it was very favored towards football and basketball, and probably rightfully so in terms of, revenue, whatnot. But that's kind of been transitioned into this new model, and it remains to be seen how Title IX is how as it plays here. I think here at USD we always keep Title IX in favor because at the end of the day, it's not like just because Title IX is not enforcing anything at this current standpoint, it's not like they're gonna they will retroactively apply it once they decide to enforce and investigate some of this stuff. And even we were talking with the NCAA in terms of tampering violations and other violations from a revenue sharing standpoint. We were talking with a colleague from the NCAA a couple of months ago when they were on a visit here. They indicate they have so much case precedent and so many instances of violations that they're just sitting on and they're just waiting to see like, all right, who's going to enforce this? And so it's just something that we just have to be mindful of. Also, with budgets tightening for sports, we've seen coaches have a more of a desire and need to have more flexibility with their roster. Obviously, coaches have an expectation to hire to be winning, right? That's their job. And given with the transfer portal and the ability for athletes to kind of move around more, coaches kind of want to have a little bit more stability and be able to remove certain athletes off the rosters. There are times where, coaches make mistakes in terms of recruiting and they bring someone in that is not up to the level of par. And, there are scholarship protections for those student athletes. So, like, our coaches can't just cut a kid and not pay them in terms of financial aid. And our coaches, I remember one time during the summer, one of our coaches was like, "Hey, the student athlete said he'll relinquish his aid, so can we send him a non-renewal?" And it's like, no, we can't do that. Even if they voluntarily say they don't want their aid, we can't just not renew them unless they violated team rules or they've done something in terms of violations that allows us to send a non-renewal. And even in that process, we had to work with council. We sent a couple non-renewals this summer where student athletes appealed it. One of them, the student athlete didn't win, but the other one brought in attorneys, and it got really messy. And so we had to bring in our general counsel, and our general counsel advised just to give them to grant them the money, and he won his appeal, which is and there's no hard feelings about that, but that just shows, our coaches are kind of panicking and trying to figure out how ways they can get money back. And it's funny, I just had a conversation with a coach today who signed two athletes on a lot of money, and he found out that they're qualifying for a decent amount of needs base. He's like, "Can we reduce them now?" And it's like, "No, we can't. You signed them to give them X amount of money, and unless it fits within the rules, I can't just revise and reduce someone just because you want to get money back so you can bring more money in." So it's requiring our coaches to be mindful of that and ensuring that, whatever you're paying, that's what you think they're worth, and that once they sign that athletic aid agreement, there's no turning back unless they decide to go in the portal, or if they've done something to violate team rules or done something to be removed from the university to get a non-renewal or a reduction. In terms of the future landscape, the House settlement has increased the day-to-day communication of legal counsel with athletic departments, and depending on the institution, more work for compliance. Although you see deregulation NCAA bylaws, the need for JD background individuals or attorneys in this field is pretty high. And I don't know if it needs to be strictly through the compliance, but as like I mentioned earlier, you're starting to see, especially at the Power Four level in like the SEC, the Big Ten, and the ACC, where athletic departments are bringing in general counsel to work within the athletic department. And then, especially with this cross-functional integration, you're seeing the role of compliance continue to shift and change at all levels. At the mid-major level, I believe you'll start seeing the role of compliance and general manager potentially being morphed into one, or essentially working in symmetric or having general manager position within the compliance office. And, especially at the mid-major level, we have about roughly, I would say, 20 athletes total that are receiving revenue sharing compensation. So do you really need a full-time general manager position for that amount of athletes? Probably not. But obviously, for our basketballs, it might be something that we have to think of from a part-time standpoint, or figure out a way in terms of morphing the compliance office and our NIL department to handle those negotiations. I think you're seeing, especially at the high mid-major levels, like a UConn or like the Big East schools, or even uh, like a Marquette, they have general managers on staff that is coming through the coaches budget as well. And so that's something that, USD we have to think of. And I know, in meetings with Kimya, with all of us, we've discussed about the potential of a general manager, but is it something that is really needed for only 15 to 20 athletes in terms of negotiations? Also, another big piece is the eligibility in academics. The House settlement has put eligibility and academic model for NCAA to the test, and potentially eroding the student model. Pending lawsuits are continuing to challenge the eligibility model, and there have been rumors, and something that our student athletes continue to ask us is that they might go from a 4 and 5, which essentially is they have 4 seasons to use within a 5-year clock, to a 5 seasons, a 5-year clock, or a 5-year seasons, 6-year clock model. And the problem with that, if that was approved, NCAA will expect more lawsuits, which could throw the whole eligibility model out the window, because there's no need for eligibility if you're going to continue to change it. Another piece is the academic standpoint. There are pending lawsuits right now challenging the academic requirements that a student must meet to be eligible for competition and practice currently. But now with the revenue sharing piece, and we just got, more guidance from NCAA, obviously, that if a student's not eligible from an academic standpoint, they can't be receiving revenue share payments. We're gonna wait to see how that's gonna hold, especially in court, because there's definitely gonna be a football player or a basketball player that didn't pass 6 units, or didn't pass 24 or the 18 units in order to be eligible, that they're going to sue and say that's against antitrust violations, that you're withholding my pay because I didn't pass 6 units. And it's going to put that to the test, and also it's going to really put the whole student athlete model to the test as well. So it remains to be seen how that is going to look moving into the future. And then also, House isn't a long-term solution and has further created instability within college athletics. To achieve long-term stability, it will require potential intervention from the federal government potentially. Currently, there were a couple bills within the House. One of them was just shut down, and it got pretty high. It was called the SCORE Act. It was more from the Republican side, but it would kind of put a halt to certain things, and it was more institutional friendly, where they were allowing to have antitrust exemptions for the NCAA, which got a lot of pushback, especially from the NFL Players Association, the NBA Players Association, that if you're going to give NCAA antitrust exemptions, you're essentially going to we're losing benefits for the student athletes. We also see one that might make its way through. I'm not sure. It's the called the SAVE Act, which is a little bit more student athlete friendly in terms of benefits and from a holistic standpoint. But I believe that there has to be some sort of federal government mandate. You're already seeing states create and pass legislation that cater towards schools in terms of revenue sharing, specifically with taxes, especially in the South, that they're essentially indicating that they don't have to be taxed like an independent contractor in the state for earning name, image, and likeness, which puts schools, especially in states like California, to a disadvantage because why would a student athlete want to come to a USC or a USC or UCLA or even a Stanford if knowing that, oh, I have to get 30% tax here in California versus no tax at all in maybe in Alabama or Georgia? Why would a student athlete want to go to a school in California if they are earning up to six, seven figures. And then also, another potential option is the collective bargaining agreement. You start to see, you're hearing that push more in college football, especially at the FBS level. I've heard Nick Saban saying we need a commissioner, we need a commissioner. But if you're going to go to CBA model, then you're going to have to essentially acknowledge and change what student athletes are. Like, are they employees? And come with the CBA, you're going to have potential employment law, labor law issues that might have to come into play in terms of that. And also, taxes has been a real struggle. The way we handle ours in terms of how we disperse it, our Teamworks wallet automatically withholds 30% from the student athlete's compensation. And for domestic students, they have the ability to elect not to have that withholding. And so if they do elect to not have the withholding, they're essentially understanding that they're on their own when it comes to taxes because if they had that 30% withholding, they're essentially the platform holds that money in a separate account, and then when tax season comes, they provide that money back to them in order for them to pay their taxes. One thing that we found out really quickly is that international students didn't have that automatic withholding. They had to have the automatic withholding. And so it was a very tricky time because obviously the student athlete thinks that student athlete or agent might be thinking like, wow, they're taking money from my client. And the student athlete's like, wow, they're taking money from me. When in reality, we found out is that there are federal guidelines and IRS guidelines that any international student or someone that's on a visa or anyone that's not a non-resident here in the United States, it's an automatic 30% withholding unless they have a tax treaty with their country. So that was one thing that we had to figure out. And with our assistant athletic director for NIL, we're just like figuring out for some of our athletes, like, okay, they're coming from Serbia. Is there a tax treaty? And trying to guide them through Sprint tax and turn and make sure they're submitting the appropriate information because if they do have a lesser percentage, they can get that lesser percentage. But if they don't have a tax treaty, it's 30%. And it's a bit difficult, especially previously, because we have some athletes that were earning money from an NIL collective. They weren't really being taxed like that because it was coming from a third party and they were using that tax exemption status as a 501(c)(3). But now, since the institution is paying that money directly, you have to pay taxes on that. And so that was something we had to, let some of our international student athletes know. We had an international student athlete that was at a Power Four school and was like, that I had never had taxes taken out. I would take my money and give it back to my family in my home country. And it's like, unfortunately, those days are over. And there was a little bit of turbulence during that standpoint as well. And so trying to navigate that as well is pretty difficult. And so for compliance offices, the name of the game is to be able to adapt to change and just continue to provide resources on a day-to-day standpoint and just focus on what's at hand from the day-to-day and not look too much far in the future. And so like I think for us and I think for a lot of compliance offices across the country, you know, just continue to provide guidance to our staff, coaches in the best way possible, and also to our student athletes in this ever-changing model. Because like I said, we've had a lot of student athletes ask questions, especially from an eligibility standpoint. Coaches kind of screaming that the sky's falling in terms of college athletics and trying to kind of talk them down a bit. We've turned into a bit of therapists in some ways with some of our coaches, especially our Olympic sports, where they feel like they see the writing on the wall, and it's just it remains to be seen what will actually happen in the future. But we just kind of have to take it day by day. And then finally, in terms of USD, I decided to enroll in the business and corporate law LLM program in fall of 2023. And one of the reasons what was because I do love reading about court cases as someone as an attorney. I enjoy that. And so I kind of saw what was coming down the pipeline, and for myself, I wanted to bridge the gap and you know re get my tools ready from a business side of things. And so I decided to get my LLM here at USD, and I really enjoy it. The classes like in-house corporate counsel, my former professor is on the call as well. That was one class that really prepared me not only for the future with college athletics, but it applied to me day to day. You know, work prepared me to act as an internal risk manager, and had me understanding that even from an in-house counsel standpoint, they wear multiple hats, and they're taking on things that they're not necessarily experts on, and how to navigate that, and what's the best ways forward in terms of providing resources and guidance from an athletic standpoint. Negotiations is something that I use to this day every day, especially trying to just have communication with agents, student athletes, coaches, and families goes a long way, especially when you can understand when a conversation is going sour and how to handle that conversation, how to react to that conversation. One thing that the professor taught me was like demeanor in that class, and so I really enjoyed that. Contracts drafting was another one, which is critical in terms of just reviewing NIL contracts, drafting and updating our scholarship agreements, and also with the revenue sharing contract as well. When I first got here at USD, our financial aid agreement was maybe a page and a half. And since then, it's about 4 to 5 pages, and it's going to continue to be more as rules change. And so taking contract drafting was a huge benefit for myself. Another class that's not mentioned on here is antitrust as well. I really enjoyed that class with Professor McGowing because he really tested us in terms of and made me start thinking outside the box, and also just thinking from a legal standpoint and applying that at hand from his experience, and also in that class where we actually had to put on a whole sort of trial in a way in terms of discussing I think it was Apple versus Fortnite, which was a really good experience in learning how to put a slide deck together and how to present, and not solely relying on looking at the slide, and be a better presenter. And then also business planning was another class that I really enjoyed, just understanding the business side of things, and how to create an LLC, and how to create a partnership, and how to create a corporation. It was fun because that class really helped me in terms of understanding what I needed to put in our revenue sharing contract. One of my project for that class, I created my own NIL third party collective where I had to create my own facts, created, who was pitching in money, and figuring that out, and creating an LLC. And so that went a long way for me as well in business planning. So I think the advantage for the LLM programs here at USD is a lot of practical courses that you are able to get real life experience on, and not just courses where obviously in law school, you have your evidence, you have your contracts, you have your property, where you're essentially just reading and trying to understand the law and apply it at hand. But like, there's a lot of practical courses where you're able to do negotiations, you're able to draft and create your own corporations, LLCs. So it's a really good advantage in terms of that program. So that's it for me. Did anyone have any questions, concerns, or anything?
Thank you so much, Victor. That was awesome. So much information. As we are waiting for people to raise their hands for questions or write their questions in a chat to me, I will quickly introduce myself, which I forgot in the beginning due to the whole sign-on issue. My name is Felina Fleck. I am the Assistant Director of the Graduate Law Program here at the USD School of Law. Victor is one of our alum, as he so kindly pointed out and highlighted some of the courses we offer. So I am responsible for admission and recruiting for all of our non-JD degree programs, which is the LLM and the MSLS. So I just wanted to share some of our information here. Feel free to take a screenshot. We have our LLM programs with different areas of concentration, like Victor did the business and corporate law concentration. We have some others. You can reach me via email, WhatsApp, phone, and also you can set up a virtual meeting with me where we can talk one-on-one if any of our programs interest you. And everyone, thank you for attending. To kick off questions, I'll read one that came in. Um, Victor, how do you go about recruiting international students now that the whole US students can earn more, potentially easier than international students? What is the new appeal there?
Yeah, so with the college athletics now paying, we started seeing a more of influx of international athletes come in, especially from the basketball standpoint. And it's interesting because it kind of started with tennis, where they weren't earning as much money as basketball, but we started to see because of the change in deregulation of rules, the sport of tennis, they have very strict delayed enrollment penalties and terms of legislation, where essentially once they graduate high school they have essentially 6 months to play pro, and then once that's done, they have to enroll. If not, then they're subject to losing seasons and whatnot. So we started to see that happening a lot on the tennis side, where you had uh, male and female athletes who were 20, 21 years of age, coming over across and start playing right away as a freshman. And it's like they played thousands of matches at a pro level where they didn't really earn that much money. And now they come here playing college tennis and they're a 21-year-old freshman, which is can be a bit difficult when you have freshmen that are 18 years old. And now with basketball, you're starting to see a lot more Europeans, especially from the Euro League, come into the States to play. We actually had two international athletes that came in this summer for basketball where they were playing pro in their respective leagues and they they did face some delayed enrollment penalties, so they were charged with 2 seasons of competition. But for them, this is like, listen, I'm coming here, I'm gonna do well, I'm also getting compensation, and then I'm gonna try to go pro. And so you're even seeing it a lot, especially from the power four side where they're actually getting like I think there was one I think from UVA where he was playing for a well-established Euro League and he is a straight up professional and he is able to come here and he has 2 seasons, but for him he was in the draft, he was potentially being drafted last year while playing in Europe, so he's coming here to play knowing that he's going in a draft in a year or two, but he's making more money here versus making money in Europe. So you're starting to see a lot more influx of international student athletes, especially from the basketball side, in terms of coming here with 1 or 2 seasons of eligibility, knowing that if that they do perform well, they're just going to go straight pro anyways, and they're able to make money, more money than what they're making in their home country.
Awesome, thank you. And then we have one more question. Do you think it is advantageous to have this profit sharing for smaller universities, or is it hurting them more when they cannot compete anywhere close to other schools?
Yeah, it's a tricky one. As an example, if any of you guys are college football
Mhm.
fans, Notre Dame wasn't put in the college football playoff, and you saw a JMU and a Tulane make the college football playoff, and you hear a commentator say, they don't belong in there. And at the end of the day, it's, the coaches, the ADs, they made the rules for this. And last year, if they had the same rules last year, one of those two teams would have been a protected 4 seed. And you're starting to hear that commentary where it's like they don't deserve there. They're gonna get killed. They're gonna lose by a lot. Um, it's a disservice to the mid majors and smaller schools. I think, in terms of the other sports in basketball, yeah, you'll start to see it. I think even last year with the NCAA tournament for the men's side, there was no Cinderella stories. And so there are potential that you might not see Cinderella stories happening anymore from a college basketball standpoint. But I think things change, trends change. So I don't necessarily think that it's, you know, I welcome, schools like us to continue to try and perform because at the end of the day you have to make revenue, and so for us like basketball has to be really like basketball is our has to be good because that they're ones bringing in revenue, so you're going to have to continue provide those resources, especially to conferences like the WCC where it's solely just basketball, there's no football. And so like I welcome it, I enjoy it. I think for me I really enjoy this part of the revenue sharing standpoint and seeing athletes make money. I think it's great, and I think you'll see a shift, and it depends. I know President Harris made a comment as well in a column where he thinks like maybe college football, like the high level achieving college football schools like your Ohio States, your Texas, um, move away and break off and do their own thing and kind of keep everything else. Because even at the Power Four level, you have schools that can't it's not sustainable for like maybe a Rutgers. It's not sustainable for a Northwestern or even a potentially Vanderbilt. I mean, they did really well this year, but is that sustainable every single year? Because at the end of the day, only one team wins a national championship. Only one team's win the conference tournament. So like, how is the sustainability is still remains to be seen. So like, even from a Power Four level, you see the huge difference in terms of how much is being spent. Like Kentucky, and it not always works out. Like Kentucky's men's basketball program spent $22 million on a roster, and they're having a not the best start to their men's basketball season. And you also see in football, like, you know, University of Miami spent a lot of money, Texas Tech spent a lot of money. And are they winning the national championship? I'm not sure, right? And so there are teams spending more money than like Ohio State football team, but at the end of the day, who's in the national championship? So it's not just even at the mid-major level, you're starting to see a difference even at the Power Four level from like the high achieving Power Fours to even like the middle of the pack Power Fours.
Perfect. Thank you so much. We don't have any further questions. Thank you so much for joining us today. We really appreciate it. We love to have alum like you stay close by us and do great work. Thank you so much for sharing your time and expertise with us.
Thank you so much.